So grateful to have everybody here this evening. My name is Attorney Veronica McClendon. I am the owner and CEO of McClendon Law and Consulting. I am excited to be here with y'all today to talk about estate planning. I wanted to have this webinar on a regular basis so that folks could come and learn about estate planning, kind of take some of the mystery out of it. Because I know for some people, it's one of those things where you don't really want to have that conversation. You don't want to talk about estate planning. But I'm hoping that with these webinars, we can take out some of the anxiety that some people may have about estate planning, and then also to answer questions that you may have that may be the things that you need to know to help you to feel comfortable going through this process. So what we'll do is go through some information just to make sure everybody's on the same page, to educate about estate planning, some of the key components that are typically involved. And then we'll talk about what steps you would need to take if you were interested in working with our firm to do your estate planning. So obviously, I would love for you all to hire my firm to help you with your estate planning, but only if we are the best fit for you. If you find that we're not going to be a good fit for you, I am more than happy to help you to find who you would be a good fit for, who would be a good fit for you. So I'm hoping that regardless of whether you are looking to work with our firm or you're just looking to learn more information or just wanting to get to figure out how to get started on this process, I want to just be available to you all today. So while I'm getting my slides up, just to give you a little idea of how we'll approach this conversation. Again, I have some slides that I'll be sharing, and I hope at the end we'll have some time for questions and answers. So you can ask whatever questions you may have about estate planning. And so let me get my slides up now. I'm going to share them with you. While I'm doing that, if y'all wouldn't mind just sharing with me, what is it that brings you here? What are you hoping to gain from this conversation? What led you? How did you learn about this webinar? And then also, what is it that you hope to be able to, what specific things, questions might you have that I can try to incorporate as we go through the information? If you wouldn't mind just sharing that in the chat with me, that'll help me to make sure that I'm not just rambling and talking about stuff that's just totally irrelevant for you all. So as y'all doing that, we will introduce this topic tonight. I call this presentation, Don't Discount Your Legacy, Essential Steps to Protecting Your Family's Future. I got this title from from many conversations that I've had with people about estate planning. Most of the people, interestingly, most people I talk to start the conversation off with, I don't own much. I really don't have a lot. I just want to make sure things are in place so that there's no confusion, there's no fighting amongst my family members. And I definitely get that. I get that people may not think that they have a lot and they're just trying to get something in place to minimize conflict. But I don't want you to discount your legacy. That's why I called this Don't Discount Your Legacy, because I want you to see whatever it is that you have that you're able to provide your loved ones with after you are gone, that can make a massive impact. Just imagine where each of us would be if someone had invested in our future after they left this life. They left something for us to help us to continue. So many of you may have had that happen, but some of us we know, some people have not had that happen, and so you can just only imagine what just a little something, $5,000, a house, a piece of land, things that you will otherwise have to come up with on your own. If someone leaves it to you, then that can just be a blessing. So that's what we're talking about today. All right, so someone wants to know how to remove deceased relatives off of a deed. That's another topic with heirs property. But I'm hoping that this conversation will at least help you to think through what you can do to make sure that your loved ones who come after you are not are not dealing with that same issue with any property that you leave behind. So this conversation is focusing more on the planning aspect of things, but we do have conversations about heirs property in other webinars where we will talk about some of the things you can do to deal with deceased relatives being on property. All right, so this is a little bit more about me. Like I said, I'm the owner and CEO of McClendon Law and Consulting. I live in Macon, Georgia, with my husband and two daughters. Graduated from Mercer and Duke Law School, and my practice focuses on estate planning. I have focused on estate planning, probate, heirs property, and farm business and succession planning for about 8 years now. Our firm provides heirs property, estate planning, and probate legal services to help farmers, landowners, and other legacy driven individuals build wealth, increase income, and secure their legacies. So, with my firm, I believe that estate planning is not just about what happens to your property after you die, but it's also about how can I use what I'm learning to enhance my life now. I know one thing that a lot of our clients have found when they work with us is that now they have a better sense of what they own. At first, things were here and there. They had stuff in the dresser drawer, they had stuff under the bed, they had bank accounts that they forgot about. And we're able to help them pull that information together and really get a sense of what they have. And then the conversations that we have help them to see what they can do with what they have. So before they might have thought, oh, I don't have much. And now we're helping them to see, well, you do have these things. And if we structure your estate plan in this particular way, it actually can go a lot farther than you ever would have imagined. So those are the kind of things that I believe can not only help you to leave a legacy for those who come after you, but also to enhance what you're able to create for yourself while you're living. So when talking about estate planning, I want to make sure everybody is on the same page. First question is, what is an estate plan? We want to start there. And then we talk about estate planning. The first thing we want to know is, what is an estate? So a lot of people say, I don't really have an estate. I'm not wealthy. I don't have a lot. And an estate is all of the money and property that a person owns, particularly at the time of their death. So if you own $500,000 in 5 houses and 2 cars and some land in California, that's your estate. But if you own $5 and a house that you inherited from your mother and whatever car that you drive, that's still your estate, and you want to have a plan for it. So your estate plan is written instructions for how your money, your property will be distributed after you die. It also allows you to plan for minor children or people who are disabled who depend on you. So you might have a sister or brother who's disabled, or you might have an elderly parent that you're caring for. You not only want to plan for any minor children who depend on you, but you also want to plan for adults who depend on you as well. And then the third thing is that estate planning includes making healthcare and financial decisions for the person while they're still alive, but unable to handle their own affairs. So it allows us to put things in place so that if we become ill or we are not able to make decisions for ourselves, then we're able to put someone in place who can make decisions on our behalf, somebody that we trust. So someone asked if this is going to cover heirs property. So no, we won't specifically talk about heirs property in this presentation, but we will talk about estate planning, which helps you to prevent heirs property. We also, during the Q&A, if there's time, I'm happy to answer questions about heirs property if we have time to do that. But this particular session is more so focused on estate planning. The estate planning typically involves passing on your personal assets, planning in the event of your incapacity, providing for your loved ones who depend on you, and planning for long-term care. So those are all the things that we include when we're doing estate planning. If you are a business owner or a landowner, your plan is going to involve a bit more. It's more than just a plan for your personal assets, but we also need to figure out, how do we pass on our business assets? everything that our business owns. If we have a business, how does, the operation, all the things that happen behind the scenes to make your business run, making sure that there's a transition plan in place for that. And then finally, passing on the know-how, making sure that the people who are going to be receiving your business, that they know how to run the business. So it's so interesting. There's a lot of interest in heirs property today. I don't have one planned, but I'm gonna have to plan one. So if y'all are on the email list, I will make sure that I send information about our heirs property webinar, which is not currently scheduled, but I will make sure that I schedule one for y'all. So the components of an estate plan, we have a will. For some people, they may have one or more trusts as part of their estate plan. You may have a business entity that you include either as part of your business succession planning or just your general estate planning. An advance directive for healthcare, financial power of attorney, life insurance and other benefits, and making funeral arrangements. I'll just give a little plug here. I met this group called the R. Hardin Group. They're out of Atlanta, Georgia, and they help families to pre-plan and prepay for their funeral services so that that responsibility is not falling on their family members after they have passed away. So I thought that was really interesting, just to really think about those details in advance, so that when you pass away, your family members are just able to, make sure that you receive the burial that or the funeral arrangements that you've made, and that they don't have that stress of making those decisions after you're gone. So I thought that was a really helpful service that I'm looking forward to having them on one of my webinars. Also, I guess I will say, for those who asked about heirs property, if you look at our YouTube channel, the Family Land Law Firm YouTube channel, we have a few videos on heirs property there as well. So talking about wills, what does a will allow you to do? It allows you to distribute your assets to the people you want to receive them. It allows you to nominate an executor, and that's the person who's carrying out your wishes in your will. It allows you to fund a trust, maybe multiple trusts if you need them. And we'll talk a little bit more about, will we talk about that? I don't think we will, so I'll talk about a minute here. It allows you to fund a trust if you need to, nominate a guardian and trustee for any minor children you have, and then also adults who depend on you. And then finally, if you are someone who has a charitable legacy that you like to give to particular groups or particular organizations, then you can continue that legacy of charitable giving through your estate plan. So I'm going to talk about numbers 1 and 2 more detailed later, but number 3, funding a trust, I wanted to mention a little more about that now because I don't think I cover it later. Through your will, you can basically say, when I die, I want certain assets to go into a trust if certain conditions apply. So if I have a loved one that I'm leaving things to who is currently a minor, so for example, I have kids who are both under the age of 18, I couldn't leave them property directly because a minor cannot inherit property. However, in my will, I could say, if my children are still under age 18, I want their property to go to them in a trust. But if they are over 18, it can go to them directly. So that's one way you can create a trust through your will. Or you might have a loved one who either is disabled now, or may develop one in the future unexpectedly. You can create a trust that says, if anybody I'm leaving something to through my will has a disability, and if receiving property from my estate would harm their eligibility to receive certain benefits, I would have their properties to go to them in a trust. But as long as everybody's healthy and well, then they can receive their property outright. So you can create a will that has those contingency provisions in there in case some circumstances come up where your beneficiaries can't receive property outright. Give me just a minute to get this water. Some reason I put on the opposite corner of the table. Through your will, you can distribute your assets. And that could be home, land, other real estate that don't have survivorship provisions. And when I say survivorship provisions, that's something that if you own property with someone else, you can have something in the deed that says when one of you passes away, the other one receives the property. But whenever you don't have that special language in there, then your will can control where the property goes after you die. So that can be dealt with your will, money from bank accounts, personal property such as vehicles, jewelry, furniture. Those things can be distributed to your loved ones through your will. But your will does not impact life insurance policies, pensions, or retirement benefits, basically things that have beneficiary designations. If you have named a beneficiary on those documents, if you have not named a beneficiary on those documents, they may become part of your estate after you die. And so in that case, your will can direct where those assets go. Your will can allow specific gifts to be made or residuary gifts to be made. Your specific gifts are, I want my sister Susan to receive my house. I want my brother John to receive my 1964 Ford Mustang. Or yeah, I shouldn't even try to say anything about no cars. I don't know anything about cars. But your classic car from the 60s, you may say, I want this to go to this particular person. That would be a specific gift that you can name in your will. A residuary gift is basically like everything I own when I die, I want it to go to these people. I want John to get 10%. I want Susan to get 50%. I want Suzette to get the remaining 40%. You could put that in a residuary clause so you don't have to name specific items, but you can just say, hey, put everything together, split it up so everybody gets this certain percentage. You can put language in there that says my executor can sell it and just give them money. However it is you want to do, we can customize that. As estate planning attorneys, we can help you customize your will so that it can be distributed the way that you would like it to be distributed. So we're talking about a will now. A will is going to be different from a trust, and we will talk about those differences in just a moment. So your will not only allows you to name people who would receive your property, but it also allows you to nominate an executor to handle your estate. The executor is the person who is appointed to carry out the terms of your will. I always recommend for my clients to name a backup executor as well, because there's many cases where the first person you name either may be deceased before you die. You don't want to have to redo your will just because someone died and everything else is good. But then also sometimes situations come up where the person has died and you haven't had a chance to update your will. So you want to make sure that you name a backup executor, someone who can take over in case your primary executor is not able to serve, or sometimes they don't want to deal with it, not because they're being mean, but they, time has passed and they were willing when they were 40, but now that they're 70, they don't really want to handle that job anymore. So sometimes people lose the desire to serve, or they're not able to serve like they used to. They may have moved out the country, they're not able to do it anymore. There can be multiple things that happen. So I always encourage people to name at least one backup executor and then someone to the backup as well. You want to select a responsible person that you trust to serve in that role. And their job is to pay off the debts that the deceased person owed, distribute their remaining assets to the beneficiaries. If there's any kind of lawsuit that is either pending or needs to be filed, the executor can represent the estate in court proceedings. And the executor can also carry on any business that the deceased person had until those responsibilities can be transferred to someone else permanently. So the key thing with the will that differentiates a will from a trust, one of the key things is that you have to probate a will. A will not transfer assets from a deceased person's name to the people named in the will until someone takes that will to probate court and asks the court to verify the will and to appoint the executor. Until that happens, the will is almost just like a piece of paper. It does not have any power until it goes through probate court. So that's very important. It's a common misconception that people think if I have a will, my family can avoid probate. No, a will not allow your family to avoid probate because a will is designed to go through probate court. If you want to try to help your family avoid probate, and I say try because it's not foolproof, but we can do everything we can to make it less likely that probate will be required, you would want to create a trust. So someone asked the difference between a will and a trust. That's really the key difference, is that a will has to go through probate. A trust can transfer assets after a person dies automatically without probate being required. And so a lot of families like this option these days because then their family don't have to take that extra step of going to probate court. They can just have the trustee who comes in after the person has died to take over as trustee, and they just continue to manage the assets in the trust if that's how the trust is set up. Or they can go ahead and start distributing the assets to the family members that, or the individuals who are named in the trust to benefit from the estate. So that's the key difference between a will and a trust. I'm going to talk a little bit more about trusts. They're becoming more popular. When I first started doing these webinars not webinars, but started doing estate planning workshops years and years ago. Not that long ago, but you know what I'm saying. Some years ago, I used to tell people most people don't need to worry about a trust, but they're becoming more popular because of being able to avoid that probate situation. And then also just it allows you to have a little more control over how things go, not only after you die, but also if you became incapacitated. So if you become unable to handle your own affairs, a trust can serve as a great tool to ensure that there's somebody in place to immediately take over and keep things going. One area where I see this as being really beneficial is where someone has a house that has a mortgage on it. I have seen it happen far too often where someone dies owning a house with a mortgage on it, and then their family members take a long time to go to probate court to get somebody appointed over their estate, and the family ends up losing the house because there was nobody able to handle the mortgage company with the concerning the house. With a trust, that trustee can come in and tell the mortgage company, hey, the owner of this property has died. I am the successor trustee, and I will be handling this mortgage and handling this house from here on out. It allows things to happen a lot more quickly so that there's not that delay that can result in the family losing the property. So, what is a trust? A trust is a legal arrangement in which one party takes responsibility for the property or money of another party and manages it for the benefit of one or more other parties. There are many different types of trusts. They fall into two categories. They're either revocable trusts or they're irrevocable trusts. And I have revocable living trust. I shouldn't have put that. It should just be revocable trust. I do call my revocable trust revocable living trusts, but they're not always called revocable living trusts. The key thing to keep in mind is that it's either revocable or it's irrevocable. Revocable means that it can be terminated, it can be revoked, it can be changed with no problems. Irrevocable means that under most circumstances, it cannot be terminated, it cannot be changed unless there's certain conditions that apply. And those conditions are usually stated in the trust document that creates the trust. And you also want to make sure that those circumstances help you accomplish whatever your goal was for creating the irrevocable trust. There are a lot of reasons why people create irrevocable trusts versus revocable trusts. Some of it could be for estate tax purposes or for asset protection in the event of needing to apply for Medicaid to go to a nursing home, or asset protection if you have a profession that's a high-risk profession. You might want an irrevocable trust in place. In those situations, you have to be very careful about the circumstances that you allow for the trust to be changed. Because basically what you're doing is creating something that is separate from you as a person and that is outside of your control. And when it's separate from you and outside of your control, then people can't say that's your property. So for example, let's say that I am a person who owns a trucking company, and just with the way that those big trucks are, a lot of lawsuits, and it's very likely that people will sue me at some point for everything I have because of something involving one of my trucks. I can put certain assets into an irrevocable trust so that it's treated as separate from me. And if somebody were to try to sue me because of something that happened with one of my trucks, they would not be able to touch the assets that are in the irrevocable trust. Because for all intents and purposes, I don't really own it. It might be an asset that's in the trust that benefits me, but I can't say what happens to that asset. I can't control it because I put it in an irrevocable trust. I put someone else over it as the trustee. So basically, it's treated as if it's not my property. When it's a revocable trust, it's created so that it's pretty much treated like it's your property. So for most estate planning purposes, when people want to have a trust that replaces a will, they're going to have a revocable trust that they can change and modify as long as they're healthy, in their right mind. But if they become incapacitated or after they pass away, that trust cannot be modified. And so there's different reasons why you would do that. But the goal with a revocable trust is to allow there to be maximum flexibility and control so that you can use the asset as if it were your own property. So this illustration is designed to show you how a trust works. I hope that it accomplishes that purpose. You have here your trust property. It could be real estate, it could be cash, it could be all sorts of things. Anything that a person can own, a trust can own. So you have that asset and you put it in the trust. And the trust is it's not like a physical structure or anything like that, but it's a framework or a relationship that's created so that the property will be handled a certain way. You'll have a trust agreement or a trust instrument that dictates how that trust is set up, who's going to be over the trust, that's the trustee, how the property is supposed to be managed, and then who receives the property at certain points in time. So the trustee, again, is the person who has control over the trust. They manage the property in it, and they make sure that it's available for the beneficiaries. When you have a revocable trust that is set up for the purpose of estate planning as a substitute for a will, then usually the person who creates the trust, which is also called the settlor, the grantor, or the trustor, that person is often the person who puts the property into the trust. They also are the trustee, and they also are the beneficiaries. And so what that means is that they control everything and they benefit from everything. But if that person dies, of course, they cannot be the trustee anymore, and they cannot be the beneficiary. So someone else will come in as a successor trustee, and then the beneficiaries would come in to receive the property or to be beneficiaries of the trust after that person, the original person, has died. That's how trust works. I hope that's explanatory. I hope that helps to clear up any confusion. And as I mentioned before, there are a lot of reasons you might have a trust. One of them I didn't mention was privacy. Some people don't want all their business to be out there in the public. And when you go through probate court, your will becomes a public document that anybody can access. And the proceedings that happen in probate court are public. So, for example, you might have a niece that you love very dearly. Not necessarily that you love her more than all your other nieces and nephews, but she was special. She helps take care of you, and you help raise her, all these different things. You might want to leave that niece $100,000, and you don't want your other nieces and nephews to know you left her $100,000. So you might put in a trust, because if it's in a will, I leave my niece $100,000, everybody gonna see it. Not only her sisters and brothers and cousins, but the creditors are gonna see it. the neighbor is gonna see it, the ex-boyfriend is gonna see it, everybody's gonna be able to see that this person got this $100,000. But if it's in a trust, it's kept private and it's not everybody's business what this person has gotten. So a trust allows for privacy. It allows you to provide assets to minor or disabled beneficiaries, people who are not able to manage things on their own. It allows you to leave it to them in a trust. Spendthrift beneficiaries, which means that they like to spend money and they may not be the best people to manage their assets. You can leave it to them in a trust and put somebody else over it. Also, there might be situations where the person is not an irresponsible person, but they may have a lot of liabilities. And so you can put their asset into a trust, whatever you leave to them into a trust, so that creditors can't come after it. Asset protection, I mentioned that. If you have a high risk profession, or even if you want to, you can use it like a high risk profession, or in event of planning for long term care, then you might want to put your assets in a trust so that for long term care purposes, if you were to use Medicaid to help pay for a nursing home after you die, then the state is going to come after your estate looking to be paid back for what they paid for your nursing home care. And there are certain types of trust that we can create to protect those assets from the state getting it after you pass away. And so some people would want to have a trust for that purpose. You can use a trust to hold and manage family property. So here's a nugget for those of you who are interested in heirs property. Some people will like to take the property out of heirs property status, which means that all of these different family members own the same property, and put it into a trust to where you have family members serving as trustees. They're going to manage the property for the benefit of the family as a whole. But as family members die, their estates are not becoming attached to the family property. It's not just going willy-nilly to different family members and you lose track of who owns what. With a trust, you can kind of keep everything into a single entity, so that as people die, as people become disabled, as family members come and go, you can have a centralized way of managing the asset so that it stays in the family and benefits the family, regardless of who's in the family at any point in time. And then also, as I mentioned before, trust allows for your property to transfer automatically to your heirs if you became disabled or after you pass away, without having to go through probate court, without having to start any kind of court process to change the ownership. See, I've been using this slide since 2021. I need to update that date. An advanced directive for healthcare. So we've talked about wills, we talked about trusts, and these are some of the documents that we help people put in place to help with incapacity planning. An advanced directive for healthcare allows you to express your healthcare and treatment choices in advance in case you later become unable to communicate those choices yourself. So it allows you to name an agent, your durable power of attorney for healthcare. That's the person who can make medical decisions for you if you're not able to. Your living will, which is part 2 is your living will, where you get to state your healthcare preferences. If you were terminally ill or if you became permanently unconscious, what decisions would you want made? Would you want to be put on a ventilator? Would you want to feed into? Would you want to take fluids by IV? Those are things you can state in your healthcare preferences on your healthcare directive, so that what you want is happening and not what other people think is best for you. It's keeping that stuff from happening. Then also you can nominate an adult guardian. In the unlikely event that you got to a position where you're not able to care for yourself or make decisions for yourself, you can nominate an adult guardian to take care of you if you became incapacitated. And these are things that are so important just to have in place. Things happen, life is unpredictable. And when we have this kind of document in place, then we know at least some of the things that will happen instead of everything being up to chance. I've had a case where someone was they were perfectly healthy as far as we could tell. They had a freak accident. And within 2 or 3 days, they were totally unable to communicate for themselves. And they were married, but unfortunately, because they didn't have a power of attorney in place, which we'll talk about next, then their spouse had to go through court just to be able to make certain financial decisions for them. And that became a huge issue. So we want to make sure we have healthcare directive, financial power of attorney in place. Even if you don't have a will or a trust in place, you at least want to have these documents in place, just so that you are taken care of while you're living if something unexpected were to happen. So the financial power of attorney allows you to select someone to handle your finances if you are unable to handle them on your own. You get to determine what aspects of your finances your agent can handle. One thing to keep in mind, just like I mentioned before, without a financial power of attorney, a court proceeding may be required to give someone power to handle your finances if you become unable to. And it's simple things like your spouse or just anybody needs to be able to get into your online banking so that they can make sure that your bills are paid. If they lose the password, there's no way that they can get the password if unless they have your email and all that. But we just everything's so digital for us these days. And having a power of attorney can give someone else authority to access records for you or access digital services for you if you are not able to do it yourself. The important thing about a financial power of attorney to keep in mind is that it terminates at death. So I've heard a lot of times when people say, "Oh, I'm so and so's power of attorney. I should be able to make decisions for them." But if they're deceased, your power of attorney has ended, and now we're getting into the realm of having probate court involved or having a trust or a will in place. Someone said that they can't hear me as well. I'm gonna try to make some adjustments to make sure there's no issues. I hope it's better. Okay. Good. All right. So just to clarify, a financial power of attorney is also called a durable power of attorney. And what that means is that when you become incapacitated, that power of attorney stays in effect. Most of the times when I do a power of attorney for my clients, they want to maintain all power over their own business as long as they're healthy and able to do so. They say only in the event that I become incapacitated, unable to handle my own business, do I want somebody else to become my financial power of attorney and be able to make financial decisions for me. So when that happens, that power of attorney is not effective until the incapacity happens. But a durable power of attorney is one that when you are healthy and well and you say, I'm going to allow this power of attorney to be in effect, and even if I become incapacitated, then it's still effective. Because there used to be, or there are still some powers of attorney that are only effective as long as you have capacity. If you lose capacity, if you become unable to handle things for yourself, those powers of attorney will terminate. But a durable one endures as long as you are, if you're healthy, then it also will continue even if you became incapacitated. So, but they still, no matter what kind of power of attorney, always ends when a person dies. Life insurance and other benefits. As part of the estate planning process with our firm, I always want my clients to look at their beneficiary designations. A lot of times we don't realize we may have deceased loved ones still as the beneficiaries on our policies, or we may have a policy where we leave benefits to a grandchild who's underage, and we didn't realize that it's not a good idea to leave life insurance to a minor child. Because if you leave life insurance, if you have a minor child as a beneficiary and you pass away and they're still a minor, a conservator has to be appointed through the probate court to receive those assets for that minor child in many cases. Sometimes the parent, the biological parent, can receive those assets for them, but sometimes the court is going to, the law is going to require that the court appoint a conservator to handle those funds for that minor child. So you want to make sure that you carefully review your life insurance, retirement benefits, pensions, whatever you have, to make sure that the beneficiary designations are up to date. So the question, what happens if you die without an estate plan? Your possessions, everything you own, would be distributed to your heirs at law according to state law. A judge would appoint someone to administer your estate. A judge would decide who takes custody of your minor children, or if you have an adult who depends on you, a judge will be deciding who takes care of them. And a judge would appoint someone to manage any assets or money that your children would inherit from you, especially if they're minors. A judge is going to decide all of that. And as I have here at the beginning, your possessions are distributed to your heirs at law according to state law. So it's basically like whatever the law says, however the law says your property is supposed to be distributed, that's what's going to happen. And you may not like the law, but if you didn't create a will or a trust, you really can't say anything about it because the law is going to kick in. But when you have an estate plan, then you are in the driver's seat. You get to decide in advance how things go, takes the burden off of your family, helps you to maximize the value of any assets that you pass on, and allows you to leave a legacy that outlives you. You get to design your legacy. You get to say, when I'm gone, this is how I want things to go. This is who I want to inherit my property. We want that, but a lot of times we don't take the actions to make it happen. And one reason we don't is because we have this anxiety about thinking about estate planning as this morbid, when I die, this is what's going to happen. I just got to get my affairs in order. It's something we all got to do. But when we view estate planning as a gift, it's a whole different story. So we change our thinking and we see it as a way to be a blessing to those who come after us. So when we go through estate planning with my firm, I encourage my clients first, let's talk about your goals. What is it that you want to accomplish with your estate plan? Is it that you want to make sure that your children are able to continue to be property owners and receive an income from properties that you've acquired over a lifetime? You want to make sure that your child who has a disability but can care for themselves, that they always have a place to live? Is it your goal that your nieces and nephews will have scholarship money to go to college so that they don't have to struggle to be able to get an education? Do you want to create a fund for young entrepreneurs in your community to be able to start businesses or to receive grants for their businesses? Whatever it is that you want to do, you want to establish your goals. And then once you know what you want to accomplish, you want to create an inventory. Everything you own, you want to make sure you have it documented so that it's very clear what you own and what you have to give. You also want to select your fiduciaries. Your fiduciaries are the people who you put in charge over your plan. We talked about executors. We talked about trustees. We talked about healthcare agents and financial powers of attorney. All of those people are your fiduciaries, and you want to make sure you choose people that you trust to serve in those roles. And then finally, you need to have a team of advisors. Everybody's estate is going to be different. Some people may not need a big team, but others will if you want to make the greatest impact. So you need to think about, who do you need on your team to help you to carry out your wishes. So I kind of already went into the details of each letter, but establish your goals. Like Stephen Covey says, begin with the end in mind. Think about, when I'm gone, what legacy do I want to leave? I may not even have everything I need right now to create that legacy, but it's going to start getting me thinking like, I actually would like to help other young lawyers to start their law firms in the future. So if that's my goal, what do I need to do? Do I need to set aside money for a mentoring program? Do I need to have a building for my law firm so I can host young lawyers at my firm as interns and young law clerks so that they can get some experience. Like, what kind of things do I need to put in place? Am I a farmer? Do I need to start identifying people who will take over my farm? I may not know anybody right now, but I know in the next 20 years, I need to think about someone I could be mentoring so that they can take over this farm. So estate planning helps you to think, what do I really need to do to get to the goal I have for my life and the legacy I want to live so that I can start putting things in place now to make sure that happens. Creating an inventory. Make sure that you know everything you own. Look at real property. Include heirs property. I have a lot of people who think they should not include their heirs property in their estate plan. If you own 1% of land, please put it in your estate plan, because when attorneys like me are helping families to clear title to heirs property, it helps to know if they have already put a plan in place for whatever interest in that heirs property they own. And it can help if you're doing estate planning, you know that your cousins also doing estate planning, y'all talk about it and say, we know little Bobby is, or young Bobby, you know, he might be 50 now, but we still call him little Bobby. We know little Bobby is the one who cares about this family land the most. So let's all leave our piece of this heirs property to little Bobby so that he can own a larger share of the property after we're gone. Thinking about those things, cash, bank accounts, investment accounts. If you have a farm, your farm equipment. I talk to a lot of farmers, so I always forget to change the slide so it's more universal. But if you have a farm, your farm equipment, vehicles, your valuable personal property, business interests, make sure you account for all of it. I do a lot of estate planning with people who have businesses. Oh yeah, I forgot I own 49% interest in this business that someone has, and I received this much income from it, but you forgot to put in your estate plan. So we need to make sure that we know what we have. Selecting your fiduciaries, we talked about those different roles. People you trust and people that you know can actually get the job done. You want to be very intentional about who you select for those roles. And assembling your team of advisors. You definitely need an attorney for your estate planning. You might also include financial advisors, insurance experts, agents, land use experts if you own land, business consultants. Make sure that your plan is going to make sense. And in order to determine that, you may have to hire professionals who can help you to put details in place. Now, say if you don't own a lot of assets and you don't have a lot of disposable income, I'm not saying that you got to hire somebody in each of these categories, but if you have a larger estate, if you have a business that you want to continue after you're gone, you do need to involve other professionals so that you can plan things in a way they are actually going to happen the way you had in your mind. So the question of, can I just do it myself? A lot of people think like I know how to like write and I can put things in place. I'm gonna have all my family, I'm gonna make a spreadsheet. I've heard this a lot. People like, I'm gonna make a spreadsheet and I'm gonna have it notarized and I'm just gonna like tell people what I want them to get. And estate planning is a lot more involved. Yeah, you can do it yourself, but I just don't advise it because there's just so many pitfalls. And a lot of times we don't see the pitfalls until after a person dies, and we're like, oh, this is what we're working with. When you're someone like me who does a lot of probate cases, I do a lot of probate work, a lot of heirs property work. I see how things go wrong, and I am always concerned about people doing their own estate planning. We had somebody who went on LegalZoom, or well, I'm saying LegalZoom. It was some kind of online platform. I don't know if it was LegalZoom. It might have been something else. And they basically helped their family member to disinherit them. So they had an aunt, and they said, "Hey, aunt, you don't have to pay a lawyer. I'll help you to create your estate plan using the template or using the software." And they basically set it up so that everybody got something except for the person who helped the aunt to create her estate plan, because they didn't know what those different terms meant. And they ended up creating something that was totally against what they wanted to happen. So it's very important that you at least get an attorney to help you with the estate planning process, so that you can avoid those pitfalls. So we have a lot of them that I've experienced through my practice. Family lost their property due to mortgage foreclosure because they didn't have a solid plan in place that made things happen quickly. Unexpected estate assets led to a drawn out and costly administration process. This is one of those people who claimed that they didn't have a lot, but they didn't realize that not only did they have what they knew they had, but they actually inherited something shortly before they died that caused a huge uproar later when it came time to figure out how those assets were going to be directed after they died. So if they had a will in place, they at least could have put an executor in place. They could have said who they want to receive a portion of their estate, and they could have put trustees in place to make sure that their property, that they could have put a trust in place to handle assets that went to minor children. But they didn't have that. And so we ended up with this very drawn out process. It's taken several years, cost my client many headaches and a lot of money. We have situations where someone created a trust, but they didn't put the assets into the trust. And so the family's heirs property fell into the hands of a spouse. This is a situation where there were siblings who inherited property from their parent, and one of the siblings died, and he was married to someone who was not really with the family program. And so he had a will, he had a trust, but he did not put his heirs property into the trust. He wanted that heirs property to go to his children, but it ended up going to his spouse. It was going to go to his spouse and children. We were able to work it out so that the family bought the spouse out. But if there was a solid estate plan in place, we could have made sure that that asset got to the children instead of the spouse. So it's just those things that a lot of times families aren't thinking about because they don't do this all the time like I do. So they don't think about those things that they need to address. So it's kind of the same situation. We had one where a family lost the assets to the state after a long-term care placement. So when you're selecting your attorney, you want to make sure you choose an estate planning attorney who can advise you on situations, on circumstances that apply to you. So planning around your retirement benefits, if you have them, providing for family members with special needs, long-term care planning, managing family land, succession planning for a business that's associated with your land. You want to make sure that your attorney has that expertise and you choose someone that you are comfortable with, because you may choose someone that doesn't understand your family, doesn't have your shared cultural values, or at least understand where you're coming from. And they're trying to create a plan based on the people that they typically serve, and it's not a plan that really serves your family. So you want to be very intentional about the attorney you select to do your estate planning. You want to avoid certain pitfalls, like unintentionally creating heirs property. I leave my house to my 5 children. There you go, heirs property. You've created heirs property for your children instead of being very strategic in how you title your property. Not planning for medical and long-term care expenses, leading to potential estate recovery where the state can get your assets after you pass away. Potential tax issues, you have the estate income tax, gift and taxes, retirement benefits, all those need to be planned for. And then you want to make sure you hire the right professionals. So you may be wondering at this point, how do you get started? I'm going to talk with you about the process of working with my firm if you are interested in doing estate planning with us. It's very important to note that my firm is here in Georgia. I'm licensed in the state of Georgia, and so I only can serve Georgia clients when it comes to estate planning. However, you can always reach out to me if you don't live in Georgia. Let me know. I do have contacts around the country that I trust and will be happy to refer you to. And so if you are, here and you are interested in working with my firm, you're here in Georgia, we do a lot of our services remotely, so that even if you are not in Macon or nearby Macon, we can set it up so that we can get your estate planning done wherever you are in the state of Georgia. So the next step, if you are interested in working with my firm, is to schedule a 15-minute call with steps. Actually, yes, you will schedule with me. And what we'll talk about specifically is scheduling a design meeting. And the design meeting is a chance for you to work with me one on one, and we will talk through the decisions that you want to make for your estate plan. And I'm going to turn my camera on real quick. Laptop. But we will talk with you about your estate plan and making sure that we have things, we know who the people are in your family, who you want to leave things to, what your assets are, and we can provide you with guidance on the kind of structure that we recommend for your estate plan. Um, so if you are interested in having that meeting with me, we will start with just a 15-minute call to make sure that you can get any questions answered that you may have. And just to let you know in advance, sorry, this stuff is not working with me today. To let you know in advance, our fee for the design meeting, that one-on-one 1 hour conversation, is $400. And some people are not quite ready to make that investment. And so they want to talk with me one-on-one just to get some preliminary questions answered before they go with that next step. But if you are interested in doing that, just scan that QR code. I'll put a link in the chat as well. And you can schedule an appointment with me. We can get you set up with the design meeting, and then that'll be the first step. After the design meeting, then we will be able to draft your documents if you decide to move forward with us. We will give you the fee for the full plan at that point, because then we'll know what kind of plan we're creating for you. And we'll have you well on your way to get your estate planning done. So if you are interested, you can just scan this code. And like I said, I'll put the link in the chat in just a moment, and we'll get you set up. So it's 8 o'clock now, or 8:02, not too bad. So we'll hang around a little bit more if people have questions. If you have to go, I do understand. But if you have questions, I'm happy to answer them now. You can either put your questions in the chat, or you can unmute yourself and just let us know. And I apologize if my sound got low again. I stepped away, forgot to take my mic with me. So I hope it's okay now. But if you have any questions, you are welcome to put them in a chat, or unmute yourself to ask it. And then also, if you want to learn more about our firm, here's our contact information here. If you want to give us a call to schedule an appointment, you could do that by calling our number. But thank you so much for attending this evening. And I'll be around for 15 to 20 more minutes if we have any questions. Y'all take care.